You're running the AM meeting in a second.
Yeah, it's pretty simple too. Oh, yeah. Oh, yeah. Okay. Yeah. Mm-hmm.
Like so, I put in, you know, and I
Yeah, yeah, right.
I just want to make sure that they're rolling back there too. You know what I mean? Because sometimes they assume, oh, we weren't rolling. We were just fine.
Yeah.
Just streaming.
Yeah.
yeah, sure. And that's all. Oh, cool.
Good morning, everyone. Good morning. My name is Marquita Taylor, and I'm the Criminal Traffic and Collections Manager. And I have some good news and some bad news for you. Some of our media guests, we are going to have to excuse you. We have reached capacity. This room can only hold 34 people capacity. And that includes our judges and her judicial staff. So, those 8 people, you will be able to stream via YouTube.
My attorney's not in here.
9 people gotta go.
So all of our electors will stay, their attorneys will stay, our prosecutions will stay.
Are there any family members in here that's not a defendant? You got to go. It's not a suggestion.
Can't stay.
No.
Media can't.
No.
Okay.
Whoever's in here now, if you're not the elector, you will have to go. And so far, how many people
Well,
left?
you didn't make the media leave.
4 just leave. I gotta do a recount.
4 just left?
Yeah. So just do a recount real quick.
Okay. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Plus 4.
38. So there's 38 people.
4
This
more
young
gotta
lady
go.
said that her attorney's not
He just came.
Oh, did he? Okay. Okay.
That's it.
Okay, so 4 more people
4
have
more.
to go.
Anybody here again who's not a defendant? Okay, so it's the media. So 4 media. If it's 2 media groups, you know, one group has 2 people, one person gotta leave. Other person. We need two more. One more. And we'll be at 34. Okay, we're good now.
Thank you. Thank you, just let you know, this will change one day. We are getting a new building, so we just have to be patient with the fact that we are in this area. I understand your frustration, but we work here. Believe us, we're a little frustrated with the time. We want to be able to, adhere to or, help everyone to be in here, but we just can't at this time. So we ask for your patience, and we'll see you in 2027 in our new building. On a different case.
Yeah, she got it. Okay. This is it.
SDP 74 wanted to declare a hearing on behalf of Mr. Frost, who's seated immediately behind me.
Good morning, Your Honor. Attorney John Freeman on behalf of Mary Ann Sheridan, who is seated behind me.
Good morning, Your Honor. George Brown on behalf of Mary Ann Henry, who seats to my right.
John Mike Smith, appearing on behalf of Mr. Timothy King, who's on Zoom today.
Morning, Your Honor. Dave Coleman appearing on behalf of Mr. Choate, and he is right here, seated behind me.
Good morning, Your Honor. Michael Malina on behalf of Rose Rupp, who is present in court.
Good morning, Your Honor. George Delaney and Garrett Koger on behalf of Kathleen Burden, who is participating via Zoom.
Good morning, Your Honor. Paul Stablin appearing on behalf of Amy Dagnello, who is seated in the front row.
Good morning, Your Honor. Mary Chartier on behalf of John Haggard, who is not present or on Zoom because of a medical procedure today. Thank you.
Good morning, Your Honor. Tom Kuranian is also on behalf of Mr. Haggard.
And good morning, Your Honor. Nicholas Somberg on behalf of Sean Maddox, who sits in front.
Good morning, Your Honor. Dwayne Silverthorne, appearing by Zoom on behalf of Michelle Lundgren, who is also appearing by Zoom.
David Gilbert on behalf of Ken Thompson, who's seated in the back row.
Morning, Your Honor. Derek Wilchinski on behalf of Stanley Grote, who's here with me by Zoom. We waive formal appearance in court.
Good morning, Your Honor. Michael Doval on behalf of Mr. Kent Vanderwood, who waives his appearance today due to competing medical appointments.
Good morning, Your Honor. Wright Blake appearing by Zoom for Mayra Rodriguez, who's also appearing by Zoom.
Today was the time that was scheduled to complete a series of preliminary examinations for the 15 co-defendant criminal complaint. A couple of housekeeping matters. There was a motion to reopen the proofs that was filed. The court is in receipt of that. The court did not receive a responsive motion from the people, but the court is denying the motion to open the proofs. So I wanted to make sure that was in the record. The other issue was a informal request that the court received from one of the attorneys requesting a apology of some sort because they were the subject of some investigation relative to a social media post. The court addressed any issue relative to that in chambers in private, and that individual who's requesting the apology later returned to the courtroom where the media was present, other members of the case were present, and my staff was present, and also the camera was present, and proceeded to advise everyone as to what the in-chambers conversation was. So any ramifications that came from that was attributed to the reactions and not to the court, because I handled that in chambers. And so there will be no apology from the court. Okay, so now for the reason that we're here, because there is a lot that the court wants to go over. Again, this is a hearing that marks the culmination of a lengthy and hotly contested felony preliminary examination that originally charged 16 co-defendants with 8 felony counts. Each co-defendant had been charged with count 1, conspiracy to commit forgery, counts 2 and 3, forgery, count 4, conspiracy to commit uttering and publishing, and then count 5, uttering and publishing, count 6, conspiracy to commit election law forgery, and count 7 and 8 being election law forgery. At the time of the preliminary examination, the state exclusively bears the burden of proof in this to a probable cause standard, that there's sufficient evidence that a felony was committed, and then sufficient evidence to charge each individual defendant with committing said felonies. And this is not a trial. They don't have to prove each other beyond a reasonable doubt. They only have to establish more than mere suspicion that the crime alleged, or that there was a crime and that the crime alleged was committed by the named defendants. At this juncture, the people must only provide, again, that low burden, and it's a flexible burden, but the court is the sole determiner of any credibility issues of the witnesses, and the court also is in a position to weigh the likelihood of the prosecutor's success at trial. So this is a court of law. We deal solely with the facts as presented at the time of the examination. I will apply the law as it exists provide determination about the success of this case. The state, although originally charging 16 co-defendants, moved forward with 15, dismissing one of the alleged co-conspirators in exchange for his testimony and cooperation with the prosecution of this case. It is the state's position, based on their bind-over briefing, that on the date on or about December 4, 2020, the named defendants convened in Lansing, Michigan at the Michigan Republican headquarters for the purposes of conspiring and agreeing to vote and publish a fraudulent document. That document being a certificate of elector votes to the state capitol. This meeting would take place in the basement of the Michigan Republican Party headquarters, located in the city of Lansing, state of Michigan, making venue in this court appropriate. At the time, either defendant identified as defendant Kathy Bearden or defendant identified as Myra Rodriguez started the meeting. Some of the people in the meeting introduced themselves allegedly, and there was allegedly a white male that spoke. Either defendant Bearden or defendant Rodriguez advised that the purposes of said meeting first was to develop a slate of candidates that would be presented to the state senate by 2 p.m. on that date, December 14, 2020, and that the actors being the nominee electors, understood that in the event that there was a successful recount that found that candidate for president at the time, Donald Trump, had in fact won the election, that it would be used at that time and that the electors would not have to later reconvene for a meeting for the purposes of voting. The purpose again of the meeting would be to accomplish a signing of a document. The people presented in their case in chief and in their binder brief that they believed that the group was advised of two purposes of signing the document. Again, to be presented at the Capitol that day along with the Democratic slate, and that it was not to be a contingent on Trump being declared the true winner of the election, but that the group understood that it would be presented stating that in fact Trump had won the election. The people did not indicate exactly who they believe provided this information to the suspected electors. The people alleged that at the time of this meeting there were two pertinent documents in the building. One being a contingent document that the people's witness Zamet and Hudson expected would be signed, and that would be nominating the electors, and then also a fraudulent certificate. The document or alleged documents, if the court believes that they were these documents, were signed by the group of nominee electors, and some of the Republican elected nominees then later proceeded to march or walk to the Capitol of the state of Michigan in an attempt to present this signed document at the Capitol. They were met by the people's witness, Captain Darren Green from the Michigan State Police, who denied them access into the Capitol. Green advised that the electors had already been checked. 12, which was a video that was emitted during the series of examination. And someone could be heard saying during this time that these are the other electors. On this same exhibit, the court could see and hear another party, which I believe was reported to be someone by the name of Norton, hold up a manila envelope and state, we have a copy of paperwork that was prepared as electors under their constitutional duty. He requested to speak to the Sergeant of Arms, but he was denied. Captain Green also refused to accept the envelope to be delivered on their behalf. Copies of this alleged certificate, or alternate certificate, was later received from East Lansing by the National Archives and by the General Counsel for the Secretary of the United States Senate. State police later examined during the investigation the signatures located on that alternate document and determined them to belong to the original 16 co-defendants named or identified in this case. One of the people's key witnesses, that being Agent Howard Shaw, testified that he was assigned to investigate this case in December 2022, only 2 months after his stint at the Office of the Attorney General. Agent Shaw testified that he wrote and executed numerous search warrants and reviewed countless open source videos and photos on the alleged incident and the defendants certificate to the Capitol. The elements of the charges that have been brought against these co-defendants, one being for forgery, the people would need to show probable cause that first, a document in question must have been falsely made, altered, forged, or counterfeit. Second, that the defendants falsely made, altered, forged, or counterfeited this document. Third, that the defendants did this, and when they did this, that he or she intended to defraud or cheat someone. To establish uttering and publishing, the people would need to establish first that the document in question, in this case that being the alternate certificate of electors, was either false, altered, forged, or counterfeited, and that the title of the certificate was false or made a false statement. Second, that the defendant or defendants represented either by words or actions or both that the document was genuine or true, and they either exhibited, offered, or presented said document. Third, that when the defendants did this, he or she knew that the document was false, altered, forged, or counterfeited. And then fourth, when the defendants did this, he or she intended to defraud or cheat someone. Both of these are specific intent crimes, even the charges that are conspiracy to commit said actions. The court has taken a review of the statute and the principles surrounding its statutory construction. The court has interpreted forgery, the forgery statute that is under Michigan Compiled Law 750.248, as well as the uttering publishing under 750.249, to both be property-related crimes that does not apply to the facts of this case. Even, however, if the court were to take the position that the statute applies to the facts of this case, I think that the people would still be deficient in some of the elements for the purposes of bind over. We'll get into that a little bit later. So that leaves the court with the charges of conspiracy to commit election law forgery and election law forgery, to which the people would need to prove that a person who does either of the following for any purposes under this act is guilty of forgery, that they knowingly make, file, or otherwise publish a false document with the intent to defraud, knowingly makes, files, or otherwise publishes a document that contains false signatures with the intent to defraud. The court has reviewed and heard all of the testimony over a series. Originally, we tried to do this in two settings. As you can see, we can't fit everyone in this courtroom. And then due to some of the medical issues and or mental health issues of some of the co-defendants, it ends up being three settings. And because of the voluminous nature of the evidence that was presented, parties needed time to go over and digest that information. And then the court had to give leeway for spent into receiving testimony in this court. So the idea that the court in some way delayed this matter is preposterous because of the nature and the monumental nature of the case, and then the amount of defendants that they can't even fit in one courtroom. And so the court again reviewed all of the testimony and reviewed the people's bind over motion as well as each defendant's responsive motion in opposition, and then the court makes the specific findings. The people presented a large amount of evidence, including testimony evidence, some videos, photographs, text messages, and social media postings. The people's key witness, at least who the court believes was their key witness, was Mr. James Renner. He was originally one of the alleged co-conspirators charged in this case, and I believe provided some very critical and crucial testimony. He testified that after requesting Janelle Leonard, who was the chairman of the Clinton County Republican Party, he attended the meeting in Lansing at the Michigan Republican Party headquarters on December 14, 2020. Prior to attending this meeting, he testified that he was not aware of the purpose of the meeting, but that he would be filling in for an elector. This wasn't his first time in the building. This wasn't his first time being contacted by Janelle Leonard to attend some meetings, so it didn't strike him as something out of the ordinary or odd. There were approximately 30 people in the room. The meeting was held in the basement of the building. Proposed Republican electors that are began to introduce themselves, which indicates to the court that some of them didn't know each other. He stated that the purpose of the meeting was then announced, and that it would be the signing of a document, and 2 individuals would needed to be voted in as replacement electors. Leonard further testified that he was nominated to replace Elector Gerald Walls. Renner's testimony was consistent each time he took the stand, which was 3 times during the course of this series of these these examination methods. He stated that his takeaways after the meeting, which he also stated per his normal course of business, he memorializes or documents and sends an email when he attends a meeting to people, that his takeaways from this meeting was that they were there to develop a slate to be presented to the state senate, whom they were told could decide which one to adopt, and that if the popular vote results were ever overturned, that the electors would not later have to reconvene. He identified that Attorney Flynn from the Trump campaign was present at that meeting. He also determined, or it was determined, I should say, through Agent Shock's testimony and investigation, that Flynn was present and involved in this meeting. Renner testified and identified during his testimony the cover sheet and a signature page that was presented to them and allegedly signed. Renner testified under oath as people's key witness, and the only one of the co-defendants who testified or of the people's witnesses, that is, who was present during the duration of this meeting, because the people called a lot of witnesses, at least in the first iteration. But Mr. Renner was the only one who was present during this meeting. So he's the only one, other than the Walls, who could talk and not have his right to remain silent be infringed. And he testified that at the meeting there was no intent to defraud, forge, or etc., and that all of the proposed Republican electors that he encountered were trying to do what they believed was the right thing. Renner testified that they were told that this was an appropriate process by the leaders and the attorneys that were present at the meeting. Renner stated that he believed that if he believed a crime was being committed, that he would not have attended the meeting, and that he would have even challenged the process if he believed that they were trying to commit some crime. He identified or stated himself to be a former law enforcement person and through the Michigan State Police, and that he prides himself on following the law. Renner states that they were led to believe that their actions were a part of some legitimate political strategy. His understanding was that no one there was to defraud anyone, and he witnessed nothing, based on his testimony, that would demonstrate a culpable mind. Those are Renner's words, those are not the court's words. This is the people's chief witness. Renner testified it was his belief that the Senate could receive both slates and then decide which one they would accept, but that his intent was only for the document to be used if Donald Trump was declared the legal winner. Renner stated he was unaware of what happened with the envelope that allegedly contained this document of alternate signatures that they signed after being turned away from the Capitol, and he also had no clue that the documents were sent to Washington, D.C. There was never any testimony from any witness called by the people or defense otherwise about discussions being had about sending or even considering to send these documents to D.C. This case hinges on the element of intent of these actors. And it's the actors that are named in this particular case, which are the nominated electors. This is not the intent of Flynn, the intent of Chesbro, Giuliani, or Donald Trump, but the people that were actually named in this case. Because our state didn't charge, although Agent Shock did say that there were those other individuals listed were unindicted co-conspirators. They were not charged in this case. And so intent may be determined by what these actors, these defendants named here today, did or what they said. The court, can attribute much of Mr. Renner's testimony to the understanding and the mindset of his co-actors. And that's much, or if not even all of that testimony. Other than and that's because he was the one that was present, and the information that would have been shared with him would have been shared with the others, if that makes sense. Also, the people called multiple witnesses, and their testimony tends to align largely in part with Mr. Renner's testimony. The people called Troy Hudson, political director for the Michigan Republican Party, testified that his understanding of the purpose of the meeting and the document was to confirm the elector nominees were prepared to vote if Donald Trump later declared the winner of the election, and so that his belief is that the intent of the document was to be contingent. And the court recognizes that the document in question does not say contingent on it, but I think that's semantics. I don't think that the fact that it didn't say contingent doesn't speak to the original intent of the document. Again, intent can be inferred by what they did and what they said. And so witness Stuart Foster testified that he was specifically instructed not to tell the electors why they were coming into the headquarters. I think that was intentional, and I think that information or that direction was from those unindicted co-conspirators who were attorneys and supposedly led this meeting. People's witness Tony Zammit testified that he was told that the electors would sign an affidavit stating that if evidence was found that would overturn the result of the election, that the electors would be willing to serve as electors. Zammit was clear that the intent of the document was to be contingent, and that he saw Flynn pick up the document and later overheard him make a statement to the effect of, "Can you believe I have to send this to the Secretary of State or National Archives?" But again, we have Renner, who said that there was no testimony, that he had no clue that that was going to happen. Zammit also testified that he believes that the electors just listened to what the lawyers who were present made them believe, and that Michigan would be disenfranchised and lose their vote if the election was later overturned, and that this was based on the Hawaii case, which again they were made aware of by these attorneys that were not named in this case. The people's witness Zammit also testified that he believed the electors were misled and taken advantage of by Flynn, who was an attorney. This aligns also with some of Renner's testimony. He stated that he believed that defendant Maddox, this is Zammit, Michon Maddox, might be culpable. And the court did draw from the proofs that defendant Michon Maddox did seem to be one of the few defendants that had direct communication with the Trump lawyers campaign. People's witnesses, or witness Laura Cox, also testified that she received a call from the Trump campaign and lawyers, and that the plan, as she knew it, and she's one of the creators of this meeting, right, the organizers, that the electors were to convene and sign the document stating that if the election was overturned, the electors would serve their duties. She thought this was a good option versus other documents that had been shared with her. Her testimony was that she provided the document to the Michigan Republican Party staff to present at the meeting. She had a key role there. It was her belief, as the person case pending, that there were cases pending that could impact the election. That was her belief, and that those pending cases could affect the results, and that she wanted, or that they wanted, their document in place in case the election was ever overturned. She helped organize this meeting. She also testified that she believed that the slate sign would only have power if the election was overturned. This was also based or consistent with Renner's testimony. And so it's easy for the court to assume that this was the idea that was conveyed at the meeting. People's witness Terry Land, who was an original nominee elector, was the only witness, I believe, that the court could reasonably believe or be confident had some sophisticated knowledge about how the electoral process ran, and that's just based on her prior role as a Secretary of State. She testified that she was contacted by defendant Michon Maddox to attend the December 14th meeting at the request of Trump lawyers. Land said she told Maddox to have the lawyers call her. The lawyers never called her. She never showed. The court believes that was intentional. Just like when the other witness testified that they were told not to tell the electors what they were coming here for, that that was intentional, and that the lawyers did not want to disseminate certain information to the electors. I believe that based on the testimony, the Trump campaign lawyers intentionally kept that information from certain electors, and that they were the ones who controlled the narrative of this meeting. And that again is consistent with the people's chief witness, Mr. Renner. People's Exhibit 26 is a picture of the group at the headquarters after this meeting, after they signed this document, and they're posing. And when the court reviews this picture, it appears as if this group of nominated electors believes that they're documenting something important, that this is some historical or monumental moment for them. Typically, people who are seeking to defraud or deceive do not gather and make a spectacle of that. That would be weird. Now, the people's chief investigator and witness took the stand, and he had a time on the stand. His time on the stand multiple times, because I think there was a time we had to call and recall him multiple times, called into question his credibility as well as his preparedness for this particular case. There were multiple extended pauses in response to questions that was posed to him. He's the chief investigator on this case. This is his baby. He is the only investigator on this case. But he had to make, and the court had to go off the record multiple times to allow witness Shaw to review his notes or find answers on reports, about reports, in case that he again was the sole detective on. Portions of Agent Shaw's testimony caused some confusion, or at least appeared to cause him some confusion during the questioning. And he testified that the evidence suggested that Flynn was the one who mailed the documents to D.C. Again, Renner testified the electors, he being a substitute elector, had no knowledge of this. Agent Shaw testified that he interpreted evidence he received and reviewed to believe that defendant Sheridan relied on guidance from Trump's lawyers, Giuliani and Chesbrough. He testified in this courtroom under oath that the electors did what they were told to do by the lawyers. And the court agrees with the argument made by some of the defense counsel in their mind over, that reliance on counsel's advice, although not an affirmative defense, does tend to refute the government's ability to prove intent. Agent Shaw conceded on cross-examination that there was no public record. That was his response. Agent Shaw received emails from Chesbrough after swearing to an affidavit of probable cause that would demonstrate that there was no agreement between these named defendants to commit a crime. Although he put in his affidavit that the electors were told this would be an alternate slate. Agent Shaw testified that he believed Mr. Renner was doing his civic duty when he signed the very same document that the other co-defendants allegedly signed. So that would mean that they were doing their civic duty, if I were to believe Agent Shaw's testimony. Agent Shaw testified that he moved forward with authorizing the complaint because of a concerted effort to present a slate to cause a pause in the electoral process. But that's not an element of fraud, and not an element of the charges before the court. This is not an election interference case, and there's many things that could cause a pause in the electoral process, and it doesn't mean that it's criminal. This is a fraud case, and we have to prove intent, and I don't believe that there's evidence sufficient to prove intent. I believe there's insufficient evidence brought on this record to even establish that the defendants were trained or explained to them what their duties would be, and the difference between a duly elected elector versus an elected or nominated elector. Agent Shaw testified that there were no distinctions between the actions of Renner and the other co-actors. That was mainly in response to, I believe, Gilbert's cross-examination about his client, Thompson. But if there's no real distinction and Mr. Renner was doing his civic duty, then that means that they were all doing their civic duty. The prosecution would like the court to believe that these named defendants were savvy or sophisticated enough to understand fully the electoral process, which the court does disagree. because the document that was presented doesn't even align with the level of sophistication that they want me to believe. This alternate document doesn't state it's an official document of the state of Michigan, doesn't contain a certificate of vote. No one attempted to forge the governor's signature. No one attempted to create a fake seal. There were also some social media posts that the court can interpret as for the intent from, I think it was Ms. Lundgren's social media post indicating that they were in Lansing fulfilling their constitutional right, which doesn't demonstrate an intent to defraud. It's an intent to exercise what you believe is your constitutional right. And she also stated in that post something about they were well documented, meaning that they're preserving their right and they got proof of that they preserved their right. The court could have possibly entertained the concern regarding LaShawn Maddox's culpability but for the People's Exhibit 18, which was a video, but appeared to be a press conference with LaShawn Maddox and Sheridan, which clearly states what their intent was. They clearly stated that they, and this was right after, I guess, after the December 14th meeting, where they said they were executing their constitutional right to allow the senators of the state of Michigan to receive an alternate slate, and then the senators could take further action. They didn't say, first of all, I don't know anybody doing a press conference after they're committing a fraud, but to the extent that that's what we're going to do. Their statements make it very clear that they believe that they could seek redress from their state senators, which I believe is a constitutional right. Right, wrong, or indifferent, it was these individuals and many other individuals in the state of Michigan who sincerely believe, for some reason, that there were some serious irregularities with the election or with the voting, and that somehow their candidate didn't receive all the votes that was intended from them. This is not for the court to decide whether that was true or false, but this was their belief, and their actions were prompted by this belief. It is understood presidential candidates to seek redress for a recount, and that didn't happen in this case. However, it is also understood that the Constitution of the United States provides, under the First Amendment, a guarantee that people can peacefully or peaceably assemble and petition the government for redress of grievances. And sending an alternate document or a document to the state capitol, which is what the testimony was their intention, and that's evidenced by the video. We're the other electors, and we got something that we got to get to them too. They knew that the Democratic electors were there. They were trying to sneak and get something that looks like it's the real one and replace the other one. That would be an attempt to defraud. They know that the Democratic electors are there casting their vote. They've been told something about this weird Hawaii case, and they think that they got to get their stuff in on the safe harbor deadline or by December 14th. And so the actors, based on the statement of Ms. Maddox and Ms. Sheridan, were corporately seeking to get the Senate to move and do some action, because apparently the courts weren't giving them what they wanted. And so in this courtroom, we don't really care your race, color, creed, national origins, religious belief, or your political beliefs, but we do care about the law, and that we believe that it should be applied to protect every individual equally. And I believe that they were executing their constitutional right to seek redress, and that's based on the statements of all of the people's witnesses. And so for those reasons, these cases will not be bound over to the circuit court. Each case will be dismissed. Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Your Honor. Thank you, Your Honor.
Justices, sir.
Yep.
Wow.
It's a memorial. Bless your heart.
Are you still jogging, are you?
I am, sir.
I developed some knee injuries over the winter and it's all harvest last year and everything, so I'm just now getting back to walking.
Good for you.
But at 75, it takes a little longer than.
Yeah, need some assistance? I can grab the bag.
Do you want me to zip it up so you can just wheel it?
What's that?
Well, do you want me just to make it so you can wheel it?
Yeah, that's fine.
I just don't want to break it all out.
Yeah.
You know what I mean?
No, I totally understand because I want to see if we can get one of them to talk.
So.
Can we squeeze past you guys? I'm so sorry.
We knew when we went through the
Can we
preliminary
squeeze
hearing.
past you? I'm so sorry. Thank you very much.
Yeah, I'm grateful that it came through today.
Can I get your name?
My name is Hank Cho.
Oh, you're Hank Cho. Okay. Yep. Kyle.
Thank you.
She did a great job.
Help, no, this was perfect.
She did a great
I got him with it. Sorry. I'm sorry.
With your lawyer,
You're going to the Capitol. Yeah.
Congratulations.
We still got court going on. We gotta be quiet on the way out. Let's go. Cool.
Yeah.
No, we shouldn't. No, come on.
Yes, he did. We love you. We love you.
It's worth every dime. You did. There's questions of
So I'd like to get a response from one of them. I don't know if we should follow them downstairs.
I heard they're going to do something out front, like a scrum.
John?
They're what?
I think they're going to do a scrum out.
Oh, are
I
they?
said things.
Okay.
Why do I feel so privileged that I get to stay in there today?
It's a relief for everyone.
Yes, yes. Thank you for what you did.
It's my pleasure.
You got the mic, right?
Yes.
Oh, yeah, okay.
Thank you. I know this could probably.
I did it, but I
No, I know you don't.
Oh, we were in good hands.
I love you.
Okay.
It's interesting.
Yeah.
They kept it pretty.
Yeah.
I have an idea of the attorneys, so I'd like to maybe.
I'm still on, by the way.
Are you?
So don't feel free to talk amongst yourselves.
I got you.
Well, you can leave it on.
Are you sure?
Yeah, because if they want,
Okay.
you know what I mean?
Yeah, I don't think they were. She was saying, let me know when they come to a decision. So I think they were going to cut it.
Oh, okay. I didn't know if they were still wanted to feed it to
Are we on
NBC.
No.
Yeah, lobby. And if you hold the button.
To get
No, once they get it.
Oh, I didn't hit it. But it just
If
goes
you hold it in, it won't stop at any other floor. So I'm telling you.
Come in here.
One
for
more
another
pick.
Who are you with? Here.
Along the road. Oh, thank you.
Thank you.
Swap out the lights.
Yeah. There you go.
Justice is served.
Yeah, can we get it on camera? I've just got a couple questions.
Sure.
Is that okay?
Sure.
All right.
We're gonna have one of the attorneys with us as well.
Great, yeah. We can do a double lock. I'm just going to put my stuff down here. Work. They're going to do...
Do you want to swap out the mic?
Yes, I think we should. I'm going to pop this away. I can grab it. That's okay. Yeah. You're like cooked up. I can.
As I kept saying, 7 minutes of preliminary hearing, I knew what the outcome was going to be.
Pop that. Off.
Yes, you did.
Thank you. Okay. All right. Ready? Testing 1, 2, 3. 1, 2, 3. And I think the batteries are probably dead.
She's the only one I recognize.
I know I've been with you on this for
exactly.
so I'm looking forward to hearing what you have to say.
Sorry guys, give us 1 second. Okay. You getting audio now? Yep. Testing 1, 2, 3. All right, perfect. Ready?
If you could do us a favor, if you can say and spell your first and last name for us. My name is John Freeman, Johnfreeman. I'm a criminal defense attorney out of Oakland County, Michigan.
And who did you represent?
Marianne Sheridan.
Go ahead.
I mean,
my name is Hank Choate, Hankchoate. I'm a farmer from Jackson County and a proud American.
talk to us about what today means for you guys.
Justice is served.
Yeah.
I think it's a true testament to the way the system is supposed to work. We're very grateful for the judge taking the amount of time that she did to go through everything. There was an awful lot for her to consider, and she got it 100% right. We've been saying the things that she said from the bench since the very beginning of this case. The only way to really fairly look at this is it was a politically motivated witch hunt. That's the only way that I can look at this case. The evidence, or I should say really the lack of evidence, was just astonishing. And the fact that we came this far is scary.
Can you talk a little bit about what comes next?
That'll be up to the Attorney General's office. I think we're all going to have a great day on our side of things. But if you're asking about legal procedures, where does it go? The Attorney General's office certainly has the right to appeal to the circuit court if that's what they want to do. I'd be surprised if they went in that direction, but there's an awful lot of things that this Attorney General does that's surprising.
Any opening here for civil litigation against the AG's office for unlawful prosecution?
That's certainly something that we're going to evaluate, whether there is a viable case for malicious prosecution.
For our defendants here, can you talk to me a little bit about how you're feeling?
I'd like to say that I'm overwhelmingly happy. However, I'm really kind of angry that we got to this point. This should have never happened. This was clearly malicious prosecution. Yes. I just so appreciate that Judge Simmons, who is a Governor Whitmer appointee, got it right, and she saw through it, and she held to what is just.
Amen. Amen.
And so I just so appreciate that she set aside any possible political pressure and looked at the facts and made the correct judgment.
That's why things work the way they're supposed to. That's why they work today the way that they are supposed to. Yep.
Because of the judge or because of the court system?
Because of the way that the judge went through methodically and analyzed the case, analyzed the evidence, the lack thereof, and reached the right conclusion after applying the law. She did a great job.
Yeah, I think her point on the intent was probably, she emphasized the lack of any evidence, a shred of evidence of intent by my client or any of the electors to defraud or do anything illegal. And as the judge kind of tongue-in-cheek said, you don't pose for a big picture when you're committing a crime.
Exactly.
I mean, I think that says it all right there. That we're very pleased. Judge Simmons, as John just said, methodically went through the evidence, and it's the correct decision legally, and I just can't be happier for my client.
Could you spell your name for us?
Yeah, it's Kallman, David Kallman.
And then who did you represent?
Hank.
Great.
And so what I can say as a dairy farmer my entire life, never thought I would be charged as a criminal, sitting in the courtroom. But what I can say is that watching the judge, I have to say as I was completely impressed watching her through those 7 days of preliminary hearing, how she was able to stay on track in regard to what was being asked of the attorneys towards the investigator and this and that and everything. And I've said all along is that Dana Nessel, her primary objective, whether she won or whether she lost on this case, came down to political persecution and also political intimidation. Yep. Each of us could have say, okay, we were willing to help with the turning state's evidence, but we stood solid, we demonstrated courage, we felt and knew in our hearts that we were right in what we were wanting to do, and no way were we going to bow down to political persecution or political intimidation.
Thank you.
Thank you.
Can we have everyone run through there and spell their first and last names real quick?
Just ask the same. Can we go down the line? Maybe?
Sure. Yeah.
I know we got things like
Marion Sheridan, Marian, Sheridan.
John Freeman, John Freeman.
David Kallman, Kallman.
Hank Choate, Hankchoate. We got her done!
Mr. Choate, if I may ask. All right. So we have one of these guys out.
So what I can honestly say is that
got one of these already, but
trying to think maybe if we should just get one. Who did
was taken
that?
care
Over
of.
here.
Once I decided
I want to talk to
who I was going to as
I mean,
my
what,
legal
was he just the,
Once I
He's a
determined my legal
politician.
counsel
He's running for
I felt
something.
very
Maybe he's like
confident.
either a senator or a rep. I
That's
overheard him talking. He's like, I'm just here to support them.
then honestly no.
Yeah, because if you do, Michael say, oh, you can't show
I
them."
thought he was like a,
Yeah.
I thought he was a different role. Okay.
No, that anybody was here.
Struggle with getting this one.
Another one.
How'd the shots look from this one?
That's fine. Yeah, that was good. Just cut around the, adjustment.
Yeah. You can ask him. Hi, good morning. I'm Rachel Fulton. I'm with News 10 WILX. How are ya?
Fine.
Could I possibly talk to you? Are you on the call?
Give me a minute.
Sounds good. Thank you so much. He's going to talk to us.
Okay.
Just a second.
Okay.
Yes. That'd be great. That sounds great.
I don't know. What's the situation? It's hard. It's good in the sun.
Oh, that was crazy.
Yeah. Having our
I think we were, yeah, right there with the textbook example, like you get to court early, stand by the door.
Oh my God, so
get
smart.
in.
Hello.
You have some softball questions?
Yeah, I do.
Very
yeah.
soft.
That's okay. You don't have to be an expert or anything. You know, we're just trying to talk to you about what today means, just in your opinion, okay? Were you one of the ones? What brings you out today?
I'm one of the defendants.
Okay.
Was one of the defendants.
Very good. That's a great way to describe it. Yeah. Well, are we good for? Okay. So why don't you just go ahead and give me your name and can you spell that out for me?
Ken Thompson. At the time, I was the 3rd Congressional District, substitute for Kerry Van Leyen as the presidential elector for the 2020 campaign.
Oh God. And Ken, talk to me about what today means for you.
It means relaxation. It means the rule of law does stand, which is good to see and hear. I thought the judge handled herself adroitly. The case was long, as she said it was complex. I thought her decision was proper, and she was point on point to the Constitution. She addressed the facts as they applied to her.
Yeah. What's next for you? Where's your mindset? Did your mindset shift through any of this, or are you going to continue strong in what you believe?
I've stood up with the president since 2015.
Very good. Is there anything else that we should know, the community should know from your side today?
When you stand up on principle. With God's grace, liberty prevails.
Thank you so much. We appreciate your time today. That's good. All right.
Okay.
Got enough B-roll, some posters and stuff like that.
Well, rate it. Hopefully Iceland.
What's that?
Hopefully Iceland when she was out.
Yeah, she got a
They
little
all just
bit.
sort of like.
We're good then.
Yeah, I think so. I can.
Can we get a shot of the Capitol just to have it if I just want to use it for a...
You got
I'm not familiar with that.
I love it. Let's definitely get together. Yeah, of course. Great. We're family. Thank you so much.
All right.
Nobody, I think, from the prosecutor was here. I guess. I mean, you could probably get a statement from them, you know, and do it as just a, you know, like a full screen or like, you know what I mean?
Yeah.
Unless you can get Dana Nessel.
Yeah, I know, for real. I could try and call them. Can you pop your mic in this little?
Oh, yeah.
Try and get a.
No, you're good. You're good.
Nice. Yeah.
Well, first I wasn't sure. She was just going on. I've been in situations with like,
Yeah.